minutes or so.
May it please the court, my name is Wesley Parsons. I'm the attorney for the Florida Department of Agriculture and the Florida Commissioner of Agriculture, the appellants in this matter, and I would, Your Honor, request 5 minutes for rebuttal. Your Honors, my client is often called upon by the Florida legislature to deal with some difficult matters in Florida involving agriculture. Florida is susceptible to invasive pests, and my client is often called upon to attempt to eradicate those pests. In particular, citrus canker has historically been a very serious problem in Florida.
I don't think any of this is in dispute. We need to talk about payment here. Okay, so there's no question about the importance, counsel. Go forth here and explain to us why it's not constitutional as applied, and how long are the people supposed to wait before the state satisfies a judgment?
I hope they don't have to wait any longer than the legislature makes them wait, Your Honor. You're absolutely right.
Is it your position that the legislature has full discretion as to when to pay this?
The legislature does have budgetary discretion under our constitutional...
No, I understand they have budgetary discretion. Do they have full discretion as to the timing of when to pay this, which could be 1 year more or it could be 10 years more? Is that fully within their discretion?
It is, Your Honor.
Well, the legislature just, as you said, legislature calls upon your department to, get rid of pests or what have you. The legislature just said that the DOT has to build toll roads. Are those toll roads going to be done without compensating the property owners whose property is taken?
The DOT is a great example, Your Honor, because they have a 5-year budgeting plan.
Okay, but they have to, they can't just say, we're not going to pay you, right? There's a process. You go to court. You have a taking, right?
Yes, sir. They condemn in advance.
This was an inverse condemnation. It's basically the same thing, only in reverse.
The reverse is where they say the devil is in the details, and the reverse is what causes a problem.
This is a huge detail.
It's a huge detail. If you're the Department of Transportation...
Why shouldn't we order you guys to pay?
There's no money.
There's plenty of money. There's money all over the place.
Your
They
Honor,
tell, we've been wanting a courthouse for years, so they tell us there's no money. But you know what? There's a lot of money. It says that, you haven't asked for it to pay for this, have you?
yes, Your Honor, we asked for it, and...
Last session?
This session?
This past session where we have supplemental authority that legal fees were paid for this, but no appropriation for the actual judgment to be satisfied. Was it asked for this past term?
Yes, sir, that's exactly what my client asked for. My client asked for $18 million to pay this judgment. We were optimistic for a period of time because it appeared in the House appropriation bill.
So maybe we can help you.
But maybe you can, Your Honor, but not by ordering the Commissioner of Agriculture to do something that's currently illegal.
Well, you know what? Not paying is illegal under the Florida and federal Constitution.
Every citrus canker judgment, and there have been a lot of them in the last 40 years, has been paid.
Except this one.
This one and the Orange County judgment,
Yeah.
it will be paid as well. And interest is running on it.
Broward was paid?
Yes, sir. Broward was paid. Palm Beach was paid with interest. This judgment will be paid. This legislative session was a difficult legislative session.
They all are.
This one was difficult in its own way. In this legislative session, we have a new governor who is something of a mystery. We do not know how that governor is going to exercise his line item veto. It was a tight session in that there were the budget hawks were out and there wasn't enough money to go around. My client, the Florida Commissioner of Agriculture, is the only statewide Democrat in office in Florida, in a state where both houses of the legislature are Republican. In those houses, in leadership in those houses, there is no one from Lee County or Orange County, the companion judgments we're concerned with. Those all added up to a situation where in the conference committee...
The Constitution pays no heed to that, does it? In terms of the entitlement to compensation.
Your Honor, is a guarantee of
Doesn't say you're
compensation.
entitled to get paid if the politics are right.
Absolutely, Your
Doesn't
Honor.
say you're entitled to get paid if you have committee chairs from your county.
Absolutely.
Or that the department head is the right party.
My client would love to pay these judgments.
I don't know. I'll sell the record in this case. It doesn't look like your client would love to pay these judgments, frankly.
The Commissioner of Agriculture has said as much, and I'm saying so now, Your Honor.
This commissioner. Right. This commissioner.
Commissioner Putnam, this commissioner has only been in the Capitol for a few months.
Right.
If there were a source of payment,
Didn't Commissioner Putnam indicate that the judgment was not final and therefore didn't need to be paid, and then the governor used that very language in vetoing the appropriation that both House and Senate agreed to, and at the same time touting the budget surplus that the state had?
there's a lot in that question, Your Honor. There was no budget surplus. There's money put aside every year by law because there has to be a corpus of money available for future years. Commissioner Putnam said the judgment was not final, when in fact it was not final. Later, pretty quickly, it became final. Governor Scott did veto the appropriations for the 4 counties. And yes, indeed that happened. My client did not do that. My client wanted to pay this judgment. My client has paid the Broward County and the Palm Beach County judgments when the legislature appropriated money for them. In fact, my client expedited the payment of those judgments. It did 2 things. It didn't have to, but it wanted to get that money out. Number 1, instead of paying quarterly, which is what the legislature wanted us to do, my client was able to get an amendment passed so that it could pay all the funds at one time rather than spaced out over 4 quarters. Second, my client arranged for that money to be paid the swiftest method possible, which surprisingly was not by electronic funds transfer, but was by an actual physical warrant that was delivered to Mr. Gilbert, my esteemed colleague.
Let's say this is true. Your client is eager to pay this money. What should we do?
Your Honor, I don't know the court.
I mean, can we say that's good enough?
I don't think that an illegal writ is the answer to pushing this further in the legislature.
I think in terms of our legal authority, that may be kind of all we've got. We can't, go to the legislature and lobby for you.
No, the plaintiffs have lobbied very successfully and were able to obtain payment.
But we see an obligation here. It is an absolute legal obligation. There's no discretion about whether this obligation exists. There's no discretion about whether the respondent's entitled to be paid. What can we do?
Your Honor, the one thing the court, I suggest, cannot lawfully do is order the Department of Agriculture to dip into funds that are allocated to other programs.
Well, if we order you to pay, there's a process by which you can go to the Legislative Budget Commission, is there not, and say, look, we need to do a funds transfer in order to satisfy this obligation that the court is directing us to satisfy.
No, sir, my client cannot legally do that.
Oh, yes, your client can, because the court system can go to the Legislative Budget Commission and transfer funds from one category to another.
There is no other category, Your Honor. My client can transfer 5% from one line item to another line item.
It can do more than that with permission of the Legislative Budget Commission.
No, Your Honor. No, there has to be another line item to transfer to. There is no such line item. 5% wouldn't even be a drop in the bucket.
So the obligation of your client under the Constitution is dependent on the legislature putting a line item in the budget.
That's the way the budget works under our system of government.
That's the system that is like less, it carries less gravitas, does it not, than the constitutional requirement. Constitution doesn't seem to care how you get it done, right?
It's the way the system works is that there has to be an appropriation.
The way the system works is the Constitution says you have to pay, and you haven't paid, and the court's telling you to pay. That's really sort of how the system works.
Every citrus canker judgment has been paid. It has sometimes taken a year or 2 years.
How many years are we into this one?
This 3rd year, Your Honor.
We have passed the 3rd year, correct? 3 legislative sessions?
Yes, Your Honor.
So how many legislative sessions does the legal system tell an aggrieved property owner they have to wait?
The system doesn't tell a property owner in that fashion, Your Honor. Representative government can be messy. These are the representatives, the elected
So
officials.
do elected officials and state agencies have the ability to ignore two things, one being a constitutional mandate and the other is a final court judgment that is no longer subject to review?
The elected officials within their budgetary discretion have the power to allocate the funds to do that with that result, Your Honor. And
So your answer is yes, they can ignore those two things?
the Florida constitutional mandate, which places the budget solely within the arms of the legislature, does say that.
So the takings clause is purely subject to the political process, including the option for the legislature and the governor to elect not to pay a judgment for a taking of property?
I agree with where Your Honor, disagree with where Your Honor started. That is, the takings clause is exclusively within the realm of the judiciary to obtain a judgment. To pay that judgment, at that point, it does become a discretionary matter with the legislature. So far, they have always fulfilled their mandate, constitutional mandate, to pay the judgments. It has taken too long in this case.
So I think we're back to where Judge Silverman started then. You're saying that the takings clause is really subject to the legislative discretion about whether to budget for it.
The payment, yes, everything up to payment.
But the payment is what it's all about, Mr. Parsons. I mean, if they don't get paid, you know, there's a problem. They haven't not received their just compensation.
They've always gotten paid, Your Honor, with interest. I wish this were happening faster.
I'm sure you do.
Many things in government don't happen as fast as people in other branches or on the outside seem to think they should. But in every single case, a takings judgment has been paid by the legislature. Instructing my client to, find a way will not help this matter. My client doesn't have a way. The funds are spoken for. They go to the free and reduced price lunch program, or they go to the Forest Service to prevent forest fires, or they go to other eradication programs.
Right.
There's two kinds of funds. There's trust funds. My client can only use the trust funds for the matters that they are dedicated to. There's no dispute about that. There's general revenue. General revenue is better, but that is allocated right now. It's allocated to other projects. $18 million is not available for general revenue. I wish it were. We were hopeful it would be.
Why has that become a problem for the courts? I mean, why isn't that just a problem between you and the legislature? I mean, the petitioners, jumped through all the hoops. I mean, how long ago was this taking?
The judgments became final in 2016, about
And how long ago was
3 years ago.
How long ago was it taking?
Oh, the takings ran
10 years?
through 2006.
So more than 10 years ago.
Yes. In this case, I think you're ultimately looking at the issue of separation of powers. It's not unusual for...
Kinda. But I mean, we were looking at the separation of powers issue from the other perspective. It's easy for you to say that. But what you're saying is the judgment of the courts of the state have, carry no weight, when it's an clear and undeniable obligation of the government to compensate these people.
Budgeting does work in that fashion, Your Honor. You may be familiar with the Corcoran case that came down from the 1st District last year, where it was pretty clear the legislature had the obligation to fund higher education in a certain manner. And the persons who were dissatisfied with the funding sued and sought a prohibition, an injunction against the legislature that they may only budget in a certain fashion. It was an original proceeding in the 1st District. And the 1st District wrote a very pointed decision that as much as we would like, as much as we are perhaps dismayed, aggravated, unhappy with the way the legislature functions, we, the judicial branch, cannot tell the legislature how to budget its funds, even when constitutional rights or other sorts of rights are at stake.
But we're not talking about, the obligation to fund education, which is owed to the public at large, like many of the things the legislature does. We're talking about individual rights to compensation for the taking.
Yes, sir, there are,
And there is a judicial process for determining that. And we've gone through it, and now there's judgments, and now, the judiciary is entitled to enforce that judgment.
enforcing it by way of a writ of mandamus to my client to...
Well, how would you suggest we enforce it if not by that?
I think it's up to the legislature, Your
So
Honor.
you're saying we can't enforce it? I
The-
mean, it's like angels on the head of a pin. You say, oh, mandamus was not the right thing to do, but you haven't suggested how we enforce our judgment in this case.
I suggest that judicial patience is the order of the day.
I got you.
It's always worked before, Your Honor. There's no need to create an
So if
issue.
it's 15 years from now, they finally pay it, and you can say, see there, all you had to do is be patient.
If it's 15 years of interest, I'm following Your Honor's hypothetical. That's a lot of money.
So the clients are making the
15
claim
years.
making the claim in the estates of the property owners?
But it won't be 15 years. This is the worst-case scenario we have right here
So
today.
there you go. We're in the worst-case scenario when we were called upon to do something about it.
Yeah, the thing to do is to look at the other cases that played out. It looked like this was coming also, and then the legislature paid the money. This is the Connor v. Mid-Florida case from 1990, where Judge Strickland in the 10th Judicial Circuit was very unhappy that his judgment had been pending for some period of time. He told Commissioner Connor to come down here for an order to show cause hearing and bring his toothbrush because he may be going to jail. And before anything further than that happened, the legislature simply paid the judgment, and
So
suddenly
maybe we
everything
should,
was
like,
moot.
Send a missive to Commissioner Freed?
Beg pardon, sir?
Maybe we should send a missive to Commissioner Freed? Is this what you're saying?
Your
I'm
Honor,
sure
the
she's going to be thrilled about that suggestion.
The legislature acted in that case, and it wasn't because of the message to Commissioner Connor. It's the legislature was able, in the course of its events, to budget money. There was a stay by the Florida Supreme Court. The legislature met again in next session, and they budgeted the money.
Mr. Parsons, I do not know how you view so much time so quickly.
Oh.
But you're at 17 minutes, but I'll give you your full 5 for rebuttal.
Oh, if I may argue further, Your Honor,
You can do with those 5 what you want.
I'd like to reserve them, please.
Sure.
Thank you, sir.
Good afternoon, Your Honors. Robert Gilbert on behalf of the appellees, the Lee County Homeowners and Class Council. First of all, I know Mr. Parsons joins me in thanking the court for convening unusually in the afternoon session so that you could hear this. We both appreciate it very much. Your Honors, I'm here to answer any questions you have regarding the other side's argument. I have a couple of comments and points I'd like to make initially. First of all, our view, as expressed in the briefs, is that the Florida and U.S. constitutions are contracts, our contracts with the state and federal government. They outline the rights and obligations of the government towards all the citizens of the state. It's not just our argument in the briefs that supports this. This is what we, as the bar, tell citizens. This is out in the lobby of the Stetson Law School where we're meeting today about the Constitution Revision Commission. And it speaks to the fact that the Constitution is the people's contract with government. The contract point case, which I'm sure the court is very familiar with from our briefs, decided that case that there was no protection under sections 11.066, 3 and 4 for judgments that were based on a written contract, that 3 and 4 didn't apply. If sections 11.066, 3 and 4 didn't apply to a written contract between a private party and the state, how could any court find that they apply to the most sacrosanct contract that the citizens of this state have with their government, the state and federal constitutions? It just wouldn't make sense. The takings clause of our Constitution, as you all alluded to in the colloquy with Mr. Parsons, stands above this subsequent legislation that seeks to thwart, delay, and hinder payment to our clients. The legislation that was passed in 1991, I'd be happy to talk a little bit about what brought that to bear.
Well, that brought this particular statute correct. The 11.066 was passed at, I suppose, the front end of this Canker issue. Is that correct?
Not exactly, Your Honor. First of all, 11.066, 3 and 4, and potentially 2, I've never researched subsection 2, they were passed after what we'll call the 1980s canker outbreak, when millions of trees owned by commercial citrus growers up in this part of the state were destroyed by the state under the earlier iteration of the program. People like Richard Polk, Mid-Florida Growers, Connor Nursery, those folks sued for inverse condemnation. They won. Some judges, like Judge Strickland, had less patience for the department's delays in paying those judgments after appeals were unsuccessful, and indicated that he was going to force issue an execution to sell the state farmers market. And Polk and Mid-Florida couldn't get their judgments paid either. And ultimately, after that round of judgments was resolved, and they weren't resolved as easily as Mr. Parsons may have made it out to be, after those round of judgments were resolved, the state legislature in 1991 passed the sections that we're currently dealing with. And there is no question that the state legislature passed these particular sections, these subsections, in order to try and prevent clients like ours, who during a later chapter in the Canker taking litigation would be hindered or thwarted altogether from recovering payment under their constitutional judgments. It's as clear as day. Now, that statute was never tested at all until the contract point case came up, when it was tested for the first time in the context of a written contract by a private contracting party with the state. And you'll note in the Supreme Court's decision in contract point that they allude to the fact that it was a issue of first impression. This case, our case, is the first on appeal that will address this issue as it relates specifically to the constitutional taking claim of inverse condemnation brought by property owners in this state. And for the reasons that we've outlined in our brief, we see this as simply one more step in the line of contract point to make clear that the legislature by fiat cannot prevent, hinder, or delay for some indeterminate period of time payment of these judgments, which are final and no longer subject to appeal.
And the nature of the judgments, what underlies the judgments are constitutional rights, as opposed to, say, a tort judgment.
They are not tort judgments. Yes, Your Honor. They are constitutional.
You have a judgment based on a contract, right? And
Pardon me?
You have judgments based on contracts. You have judgments based on takings. These have constitutional ramifications.
They do. In fact, Your Honor, if this was a case brought by the Lee County homeowners based on breach of a written contract against the Department of Agriculture, we wouldn't be here today. Right. Contract point applies. If this was a case based on a slip and fall tort or an auto accident case brought against a driver for the Department of Agriculture, we wouldn't be here today. Sovereign immunity would apply because it would be a negligence case, and the homeowner in question would have to seek a claim bill for any judgment above the statutory amount. And I'd like to talk about claim bill if the court has any concerns about that, because it's not something that many of us on the commercial side of practices deal with frequently, and we've learned a lot about it during the course of this litigation. But this case is only about constitutional claims. The constitutional claim brought on under Article 10, Section 6A of the Florida Constitution.
The primary difference, though, is the claims bill is granted in the grace of the sovereign.
The total whim and discretion of the legislature.
And that is not true of the right to compensation for a take.
That's correct. And, Your Honors, I would point the court, because I can't even say it as well as one of the department's own exhibits below says it. Found in the record at item number 88, record on appeal, is department's exhibit number 3 from the one-day evidentiary hearing held in front of Judge Kyle, and that is the Legislative Claim Bill Manual. And that manual on page 2 and 3 tells the whole story of what a claim bill is and why it could not possibly apply in this circumstance. Imagine a claim bill being sought. By the way, I'm not even sure if it's timely because you have to first exhaust all legal remedies. But assuming it was even timely to seek a claim bill, imagine a claim bill being sought and it's automatically referred to a special master by both the House and the Senate. Sometimes they're the same special master, sometimes they're not. Those special masters have the duty and right to take evidence, make findings of fact, reject any jury verdict or judgment or appellate court affirmance of an underlying judgment below, and recommend in their sole discretion to the legislature whether any claim bill amount should be given, and if so, in what amount. It might be 1/10 of the judgment amount, it might be 50% of the judgment amount, it could be the whole, and the claimants who are seeking the claim bill have no right to review of that.
Right, and then the legislature doesn't have to pass the claims bill, doesn't have to accept the recommendation, or if it does, doesn't have to agree to that same amount.
They don't.
Pure legislative discretion.
It is the most absolute discretion afforded to the legislature in terms of dealing with this. And these claim bills are set up for sovereign immunity cases, negligence tort cases under 768.78. The case law is very clear. We've cited them in our brief, the Weidner case, the Cersei Denny case. And I'd refer the court to item number 88 in the record.
Must, and I think I know the answer, but I just want to be sure. Is it your position that the trial court necessarily needed to find subsections 3 and 4 unconstitutional as applied to your clients here to have issued the writ of mandamus? Or was there a way for this to occur without needing to declare those subsections 3 and 4 unconstitutional as applied?
It's a great question, and it's a question that we've been dealing with now for a couple of years. And based on the Bogorf decision from the 4th District in 2016, based on the department's arguments below in front of Judge Kyle about the overarching priority of the language in subsections 3 and 4, we believe that it was necessary for Judge Kyle, for the trial court, to declare this statute unconstitutional as applied in order to thereby issue the writ of mandamus. Because barring the conclusion that these sections were unconstitutional as applied, the positions asserted by the department and the language of the statute seemingly precluded the issuance of the writ.
Well, the language of the statute would seem to include this situation on its face. One could, sometimes you see opinions that say, well, it couldn't apply here because that would make it unconstitutional. We know the legislature would not intend that.
Well,
that's my problem.
Right,
That's exactly my problem.
either way, I mean, that would be you would be prevailing on your case, just flip side of the coin.
we would be prevailing either way, but I would...
Because you would still have the constitutional, in terms of the taking, you would still have the constitutional obligation to pay.
Yeah.
If the writ of mandamus were upheld, but the court decided that the trial judge did not need to reach the issue of constitutionality of the statute, the writ of mandamus would still be, in effect, compelling the Department of Agriculture to pay. If this court can find a path to reach that result,
You won't care.
it should not adversely affect our homeowners' rights. But we didn't see that path in front of Judge Kyle, and therefore we choreographed it differently based on our reading of the statute and the other side's positions.
The difficulty with that argument, though, is because he did not address that specific issue to determine unconstitutionality, if we were to reach it without your having cross-appealed that, doesn't that create a problem when this case goes to the Supreme Court, if it goes there?
Judge Silberman, Judge Kyle addressed it in his order, where in the beginning of his legal analysis, he addressed that he believed that we satisfied all the standards for obtaining a writ of mandamus, but based on the statute's language, he felt it prevented him from issuing it, and therefore he turned to the constitutional question. We didn't have, in my view, standing to appeal a decision that he didn't make. Essentially, he didn't deny issuance of the writ. If he had
We're not aggrieved at all by the order.
We were not aggrieved in any way by the order. We prevailed in
You didn't
totality.
get less than you asked for. You got a mandamus compelling payment of the judgment.
Pardon me?
You didn't get less than you asked for. You wouldn't be asking for additional relief.
We got all the relief that we asked for, and the court reserved jurisdiction to enforce its writ in the event the department failed to abide by it.
And that really brings up the question that I have, which is if we agree with your position and we were to affirm, and it goes to the Supreme Court without our discussing the execution aspect, ultimately you could be back in the trial court seeking execution, levy, whatever mechanism there might be to enforce the judgment, apart from mandamus.
If I understand your question correctly, if this court affirms, it goes up to the Supreme Court and the Supreme Court affirms, and the Department of Agriculture still refuses to pay, we could end up, based on Judge Kyle's order, back in front of him, because under his order, he directed us, in the event of a failure to pay, to take a deposition in aid of execution and to return to his court with a very specific list of assets upon which we believe a levy could be issued without adversely affecting the operations of the department, and he would review it and make the decision on that issue.
So is it at that point in time that the department would be able to further assert the constitutionality of the statute that precludes execution?
That the department could assert it. The department...
Well, the department doesn't want you to execute.
No, of course not.
And there's a statute that seemingly says you can't execute.
And right now, based on Judge Kyle's order, that statute has been declared unconstitutional as applied. So theoretically, we can execute upon this opinion, upon an opinion affirming Judge Kyle's order, because stripped of that subsection 4, I believe it's contained in, that prohibition against execution doesn't exist. And by the way, just to know, because I think from an intellectual standpoint is important, the legislature knew exactly what it was doing here, because you notice in subsection 4, I believe, it starts with the words notwithstanding section 74091. And section 74091 is the quick take execution exception that allows execution upon state assets if the condemning authority fails to pay a judgment after a quick take eminent domain proceeding. So executing on certain state assets is not 100% prohibited under our state laws. And that's what 74.091 addresses. The legislature tried to find a way around that in crafting this hurdle. Your Honors, I'd like to respond briefly to something my colleague said. I heard numerous times something to the effect, we would love to pay the judgment. We would like nothing more than to pay the judgment. The judgments will be paid. Actions speak louder than words, Your Honor. The department, for 2 years after this court affirmed PCA, the underlying judgments, did absolutely nothing, made zero effort to try to pay these judgments. They didn't go to the legislature.
Well, the thing I mean, I understand, even if the department's in a tough position, I understand that, but there's only so much the court system can do. It can't accept that, you know,
The court-
hey, we want to pay this. That doesn't get you anywhere.
It-
You know, in order to enforce its judgment, the court has to enforce its judgment. It can't just say, well, okay, never mind.
And my point is that after 3 successive legislative sessions, 2 of which took place before this order was entered, in the middle of the trial, the one-day trial in front of Judge Kyle, the legislative session was going on. Even faced with the possibility of a writ of mandamus, the department didn't do anything to even ask the legislature to appropriate this money.
But it did this past session, according to your friend.
According to Mr. Parsons, and I have confirmed, after the writ of mandamus was issued, after the subsection was declared unconstitutional, in October of this past year, they included in their LBR an amount sufficient to pay the Lee County judgment and the Orange County judgments in full. They appeared before the Senate Agriculture Committee. They never listed it in their priorities. They never publicly endorsed it. They included it in their LBR after this order was finally declared unconstitutional. And I think to answer what all 3 of you seem to be trying to grasp, what should we as the court system do in relation to this, unless and until the judicial system says there is no more delay, you cannot defeat or undermine the constitutional mandate under Article 10, Section 6A to pay the full compensation that's been awarded. Until that day comes, this department will not pay. That's what this case has shown. And that certainly...
But what's your response to, well, we just paid the Broward and the Broward judgment, which I don't believe was the case when y'all briefed this.
The Broward and Palm Beach County judgments, appropriations were made and approved in an election year leading up.
That wasn't this session.
No, it was the prior session of 2018. There were, in the same bill was included Lee and Orange. And Lee and Orange County fell to the cutting room floor inside the factory that makes the sausage in Tallahassee. But Broward and Palm Beach came out. I don't know why. There's no good excuse for why it came out.
Was it older litigation in those
Broward and Palm
jurisdictions?
Beach were older. Broward was older. Palm Beach was actually newer because we had to retry Palm Beach on damages following a reversal. So actually, Palm Beach was the most recent judgment, and both Lee and Orange counties were older than Palm Beach. Broward by far was the oldest. But what happens inside that room is anyone's guess except for the people that are inside the room. And this provision of the state constitution, which guarantees payment, will be rendered impotent if delay, hinder, and this statute allows the legislature to decide in its full discretion if and when and in how much it wants to pay this judgment. What if it had appropriated this session $10 million in full satisfaction of the judgments that have for Lee County that are now up at around $17 million? They said in full satisfaction. It would still be in derogation of the constitutional provision. Anything less than full payment. I can go on. If the court has any other questions, I'd be happy to answer them. I took seriously your request to consider the issue of the 9.125.
Oh, yeah, we haven't gotten to that, have we?
Your Honors, at the time I filed this, at the time the appeal was initiated back in April of last year, basically 14 months ago, filed a suggestion within the 5 or 10 days that the rule provides. I thought it was appropriate. I thought it required immediate resolution. I still think that there's a strong argument to be made that immediate resolution of this issue of clearly great public importance needs to be handled. I will tell the court that in preparing for today, based on your request, I found two cases that I think probably militate more in favor of this court issuing its decision first. And they are the following. First, in Shaw v. Shaw in 2014, this court certified a question. It was a same-sex marriage case. And
I think we remember it.
okay. And
The Supreme Court has the discretion
they declined.
to take it or not. And one concern that I suspect you would have at this point in time is if we certify it up and they take 6 months or so to decide whether to take it, and they decide to send it back, now we're 6 months further down the road.
Exactly. And I think that given where we are today, given how the court has obviously read the briefs, studied the briefs, everybody has thoroughly questioned both sides on the issues, that while it will take longer and obviously post-opinion motions may further delay this somewhat, I think at this point it's less likely that the Supreme Court would accept the certification than if it had happened when the appeal first started.
So is there anything in Judge Kyle's order that you feel does not adequately address this issue? Because it's a very long order, and opposing counsel might have some comments as well, but it seems to me he went through everything as best he could, including some factual determinations based on evidence presented and a pretty thorough legal analysis. But there is so much in there that I am concerned in terms of the briefing, whether there are some things in there that simply don't make a whole lot of sense, if you follow that. I mean, there's a lot in there, and there's a couple of things that he says, well, I'm really not going to address that because I don't need to address it. And that goes back to the question I asked earlier as far as one of the issues he didn't address.
Well, the one issue that I know he didn't address was the issue regarding our position about 74091. And he didn't address it because at the time he issued his decision, the only appellate court decision that addressed this was the Mendez decision from the 4th District that's cited in our papers, and he was bound by that decision. He identified it in his at our request in his order so that it would be preserved for our review, for the court's review here, and it's been the subject of our briefing. I think that Judge Kyle addressed all of the issues that were in play in this proceeding. I think that it's important to point out and I think both sides did a great job of addressing all of those issues in the briefs. I think that one issue that may not have been flushed out in our brief, although I made reference to it, is that subsection 2 of this statute, it's not the subject of the appeal, but when you look at the contract point opinion, the Supreme Court talks about how the entire statute has to be read as a whole in order to understand its subsections. And the court goes on to talk about what was going on, and it addresses subsection 2, and it says that, and I'm paraphrasing here, in the second sentence, a person may rebut this presumption. Well, it starts with talking about that the state or state agency, when exercising its inherent police power to protect the public health, safety, or welfare, is presumed to be acting to prevent a public harm. A person may rebut this presumption in a suit seeking monetary damages from the state or a state agency only by clear and convincing evidence to the contrary. This was invoked. This subsection was invoked by the department at the liability trial below. And Judge Kyle entered an order requiring us to satisfy by clear and convincing evidence to rebut that presumption. And in his liability order, which was affirmed by this court, he found that the department was not acting to prevent a public harm. In our view, that finding, which is now affirmed and final on appeal, further supports the conclusion that subsections 3 and 4 cannot be utilized, cannot be invoked to prevent payment. I didn't flesh it out enough in our brief, but I made reference to it. I think that everything else is well developed.
So that would be a way then of fashioning the opinion to not have reached 3 and 4 as unconstitutional as applied because 2 was satisfied.
Your Honor, I don't know that it would have allowed the trial.
I haven't really thought it through yet, but it was just a visceral response.
I am hesitant to agree with that because I don't think one can get around 3 and 4 without declaring them unconstitutional as applied in this particular circumstance. And I realize how reluctant courts are, based on the legions of case law, to address the constitutionality issue. But as the Bogorf Court, the 4th District held in 2016, held that ultimately the court would have to get to this issue if payment wasn't forthcoming and the writ of mandamus could be issued. Judge Kyle found that the writ of mandamus could not be issued absent finding the statute unconstitutional. We believe that was the right way to go. We urge the court to affirm the trial court's order and writ of mandamus in full and to grant our motion for appellate fees. Thank you very much.
Thank you, Mr. Gilbert.
Even if this court were to affirm that 11.066 is unconstitutional, there still stands a statutory barrier to my client paying the funds from some source. And it's more fundamental than 11.066. It's Chapter 216, the budgeting regime for the state of Florida. It says, number 1, that my client can only pay money from a properly appropriated source. And number 2, when a governor has vetoed an appropriation, it cannot be raised again in any fashion. That would have to be found unconstitutional as well, and no such finding was made by Judge Kyle, in order for my client to pay this money. Your Honors are correct. Judge, Your Honor, Chapter 11, Section 11.066 came as a result of the litigation in Hardy County in front of Judge Strickland. The Senate decided that it did not want to see this sort of thing happen again. It wished to attach a precondition to an issuance of mandamus, and so it said that the petitioners had to petition the legislature via a claims bill in order to ripen a mandamus proceeding.
But that's not what the statute says.
It does not use the word claim bill.
And a claims bill, as this record reflects, is that it is purely, it's an exercise of grace. We're going to bestow upon you this great gift, and that's not what this is about. So, it can't be what it cannot be what they intended, or if they intended, they were misguided.
They were misguided in your view, Your Honor, because
Right.
we know what they intended because the legislative history is in this
Said that
record.
they thought that this would be claims bills.
That's what Senator Gardner said in the legislative history. That legislative history has to be taken into account. That's just not my opinion. That's what the Florida Supreme Court said in Contract Point. In Contract Point, you had another
But
agency.
you don't have to accept that they were correct in their legislative history. So what you're saying, though, then if that's the case, then these sections clearly are unconstitutional because they're applying this, they're invoking the right of the sovereign to just, in its total discretion, deny compensation for property that has been taken.
To attach procedures to compensation, Your Honor.
But the procedure is one that is totally, by definition, totally discretionary.
It is discretionary. Many procedures are discretionary. But it's a procedure, Your Honor. It's a precondition. If the precondition is satisfied, if they try, and they have to try according to the legislature, and they're unsuccessful, then that ripens. That ripens the mandamus proceeding. But they have to try a proceeding that is discretionary before the mandatory proceeding is ripened. That's So much in law is like that. The whole concept of ripeness. You don't have a guarantee that you're always going to succeed in ripening your claim. You have to try it. If you're unsuccessful, then in the end you have a ripe claim and you can go to the more serious level of remedy.
Am I recalling correctly that the trial court did not address Chapter 216?
That is absolutely correct, Your Honor.
Was the court asked to address it?
We asserted it as a defense, so yes, we did. I'll address contract point for a moment because it's the sole time the Florida Supreme Court has spoken about 11.066. In contract point, the Department of Environmental Protection discovered 11.066 and decided it would confer some sort of immunity in their contract dispute with the vendor. And that wound its way up to the First District, to the Florida Supreme Court, and the Supreme Court said, we need to figure out what 11.066 is about. What we're going to do is we're going to go pull from the archives of legislative history, and they did that. And looking at the history, they said the impetus for 11.066 were mandamus proceedings on judgments for citrus canker eradication programs. They were referring to the proceedings before Judge Strickland. We pulled that same legislative history. It's in the record now. We know that that is indeed correct, and the point of 11.066 was to put this precondition to an issuance of a writ of mandamus. Your Honor, in addressing in response a few items that Mr. Gilbert pointed out, he tells the court that my client is refusing to pay. My client is not refusing to pay. We would love to pay. We will pay when
But there
the
was testimony
appropriation is there.
taken on this sort of thing, right? The testimony was, what have you done to get payment?
But we did it in 2 steps. The legislature tells us to do
Because,
something.
Because you put it in an LBR, I mean, Mr. Gilbert makes a good point, because the court system, puts things in an LBR. We don't always go to the legislature, the legislature says, and they require it actually, you have to at least on the judicial appropriations, you have to tell them what your order of priority is. Is there evidence in this record about what order of priority this LBR was?
There was no order of priority. It was simply an LBR, Your Honor. It was the second stage. The first stage, report every single judgment in our filings with the legislature. We did that. Second stage, put it in the LBR so that they'll know that we want it. My client did that. That's as far as my client can go under principles of separation of power.
There's going to talk to the legislators, and they're standing up in the committee meetings and telling them, look, this is what we really need. I've been there. I've watched. I've done it. I know how it works.
Yeah, well, of course, the government is in the sunshine, so everything has to be done with that, with that sense. Everyone has to be registered as a lobbyist, which interacts with the legislature on matters of policy. When my client went before the committee, they listed an item that included the payment for the judgments. They weren't asked about it by the legislature. The system, as Your Honor knows from seeing it, is somewhat like we're doing today. There's one party that is in charge and is asking for information,
Right.
and the best information from the other party.
And there's a lot of discussion before you get to this point with staff, and the staff saying, what is it you really want? I mean, there's a lot of stuff like that, So you can put in an LBR. You can even stand up and say, yeah, we have this LBR. Wink, wink. I mean, you're describing a process by which it is so easy, and so far it has happened to duck the processes of the court, this absolute obligation under the Constitution, and you're asking the court system to just accept that.
My client wants to pay the judgment. You know that because we paid the Broward County.
But even accepting that, what do we do with that? Write an opinion that said, well, they showed up and they said they want to pay it, so we reverse.
There's a complicated system of statutes and rules and laws in play.
Mandamus doesn't depend on what the respondent into the mandamus petition wants to do. It is a requirement that they have failed to comply with a mandatory duty, whether they want to comply with it or not.
If there were a source of payment, my client would be happy to dip into that source and pay it because we've done it before.
And just to be clear, your client's position is, under the statutory scheme, including Chapter 216 and the other statutes that we have discussed, that a court cannot issue an order of mandamus at any point in time, that the statutory scheme is what it is. It's a legal scheme that effectively, I won't say supersedes the constitutional provision, but it certainly thwarts the ability of a claimant to get paid until the legislature and the governor see fit to make payment at their discretion.
If there's an appropriation, mandamus could very well be appropriate. If my client had an appropriation, for some reason was not dispersing it, I can see
So
absolutely mandamus
to go
is
further,
correct.
then, the court has no ability to direct the legislative process to address a judgment.
No, sir. I think I would again refer to the Corcoran decision from the First District just a year ago, which seems to be the most recent statement on this subject. That is the basic principle of separation of powers in Florida government. Mr. Gilbert referred to, should what happens inside that room being the legislature, stay inside that room? And what the separation of powers is saying is, yes, that is a room, it's its own room, it's its own branch of government, and what happens there in terms of the budgetary process does stay there. My client isn't in that room. This court isn't in that room. All we know is that the legislature in the past has done their duty and has appropriated money to pay the judgments.
So the bottom line, though, is there's no duty to pay that is enforceable unless or until the legislature appropriates.
Yes, sir.
Okay.
Thank you.
Thank you very much. Thank you both.
Thank you, Counselor.
We're adjourned. All rise. Travel safely.